If you care about the little guy, you are for patent trolls. Or at least you're not as against them as you thought. I'm Dennis Walsh, an intellectual property attorney, an electrical engineer by school, and now mostly a software developer. I started this channel to react to software legal drama and deep dive the topics to help you, the software developer, avoid royalty-free tech transfers. So a few weeks ago, Theo made a video claiming that patent trolls are killing software innovation, bullshit patents are everywhere, and everyone should go sign the GitHub petition to make inter partes patent reviews way easier.
There's this whole category of industry now called patent trolling, where companies get the rights to patents they don't actually intend to use for anything meaningful, just so that they can sue other companies and charge them for licensing of these patents when the company doesn't use anything from it. They had no idea the patent existed. They're not trying to use that piece of software. They're just trying to build something basic, like an app on the App Store or a protocol for doing video stuff live.
And let's get this out of the way. I am a big fan of Theo's content. I reacted to another one of his videos and he actually reached out to me, had a bunch of support, great things to say. I think he's a great guy. But in this video, I'm going to push back a little bit and try to broaden the conversation. I'm really going to defend 3 unpopular things. Okay, so the first one, why so-called patent trolls can serve a real function in the patent ecosystem. Second, I'm going to go over why bullshit patents might not be bullshit once you zoom out a little bit. And third, I'm going to talk about why making it easier to attack patents at the USPTO through an IPR review can wreck the exact small companies and developers people claim that they want to protect. So if that sounds insane and you think I'm a moron, just stick with me. In 15 minutes, you're going to understand this stuff way better than you do right now. On this channel, I'm going to deep dive everything so that you can understand the nuance and really sharpen your opinions. All right, so let's rewind a little bit and let's build a common foundation, part of our deep dive. Before we talk about bad patents, trolls, and the GitHub drama, we need a shared baseline. So the biggest thing to understand about patents is that there are 2 main hurdles to get them. I'm oversimplifying, but the 2 big ones are novelty, has it been done before? It's a subjective standard, you just look, has it happened or hasn't it happened? And non-obviousness. Even if it's new, would it have been obvious to somebody of ordinary skill in the art to have done that step at that time? Okay, so quickly on novelty. Has the claimed invention been practiced or described before you filed? Somebody disclosed the idea in prior art, you can't get a patent. And it can be from another patent, a paper, a manual, a YouTube video. There was one time I was doing a patent rejection against a dual transverse pumped laser, and it was a prior art from a Japanese magazine. I had to get it translated, I had to translate back. But literally, it can come from anywhere as long as it is from before the date that you filed. Non-obviousness, though, gets trickier. That's where the law basically asks, if we take a normal person of ordinary skill in the art back at the time of the invention and we hand them the existing knowledge, would the claimed invention have been an obvious step? So one of the biggest traps in the obvious analysis, and something that the courts always look at, is hindsight, because everything is obvious in hindsight. The question isn't, does this look obvious to us now, 20 years later, after we've seen it everywhere? It's, would it have been obvious then based on what people knew then? And typically, this is where I see online patent discourse just go completely off the rails. Developers look at a 1992 patent, like the one we're going to look at later, from the comfort of 2025 and go, that's trivial, it's stupid, I could build that in a weekend. And you might be right today. But the law is not asking if 2025 you can do it. It's asking whether in 1992 you, without Google, without smartphones, without app stores, would have found that obvious. And then one more thing before we move on. A patent is a property right, not a merit badge. You don't have to be selling a product to enforce it. You can sell it or license it just like any other property. The law does not say you only get to stop infringers if you also manufacture your own competing product. That's going to matter a lot when we get to our analysis of patent trolls. Okay, with that as a background, let's get into the bullshit patents. But let me say this up front. I am not passing judgment here on whether software patents should exist at all. Courts have been conflicted. I've been conflicted. There are strong arguments on this on both sides. I mean, I filed software patents myself, including work on the PlayStation 3 encryption algorithm. If you want a full video on software patents as a category, let me know in the comments and we'll do it. In Theo's example, he cites Lodsys for the bullshit patent.
The patent in question covers methods and systems for gathering information from units of a commodity across a network. which apparently translates to in-app purchases. Do you understand how fucking stupid that is?
This is the one that got really famous in the early 2010s for being asserted against app developers doing in-app upgrades and purchases, despite Apple and Google both licensing the patent. Here's what almost nobody mentions when they dunk on this patent. The priority date for this patent family goes back to the early 1990s, long before iPhones, app stores, or in-app purchases. I mean, I had a Mac 2CX barely in color. I was logging on to Prodigy with my 14.4 modem. Shout out in the comments if you were rolling with me on Prodigy. If you look at the patent, it's not really a patent on in-app purchases per se. At a higher level, it's about embedding a network feedback and update module into a lot of everyday products, units of a commodity. So those products can send usage and preference data back to the vendor while being used and download new questions, support, or capabilities over a network. Okay, quick 30-second primer on how to read patents so that you can judge these more intelligently. This is how attorneys generally do it. The first thing you want to look at is the priority date. That is the relevant time period that you have to evaluate novelty and obviousness against. So if you see the big issue date, that doesn't matter. What matters is what they're claiming priority to, and that's in this box here. Okay, next you want to look at the figures, and then finally look at the claims. The claims are the legally enforceable part of the patent. Focus on the independent claims first, the ones that don't depend on any other claims. Dependent claims usually add narrower variations and backup positions. To infringe a patent, every claimed element has to be present. If the claim cites A, B, and C, and somebody does A, B, C, D, that is infringement. But if they only do A and B and not C, they didn't infringe the claim. Essentially, the Lodsys patent comes down to turning devices into the network, continuously learning from the network and the telemetry and how the product's being used in the field, and have a continuous update cycle. Obviously, I was alive in the 90s. Most of you probably were not. So trust me when I say back then, this combination was not exactly normal. Typical market research looked like phone surveys, people sitting in a single computer answering questionnaires, and other very mechanical ways of getting feedback. Then fast forward a decade or two, app stores appear, in-app upgrades become standard, and Lodsys, who acquired the patents later, says, your upgrade flow fits inside of our patent claims. Now, I want to be really clear. I am not defending Lodsys' decision to threaten tiny indie developers or any size developer. That kind of enforcement strategy, especially where Apple was already providing the infrastructure and was paying them licensing, they were paying Lodsys licensing in the background, is exactly what gives the patent system a bad name. But of course, how they enforced it is separate from the question, was the original invention non-obvious at the time? To answer that, you have to mentally travel back to the priority date and ignore everything that came after. That's what non-obviousness analysis is supposed to do. So when we say this is junk because in-app purchases are obvious now, we're doing exactly what the courts warn against, smuggling in 20 years of hindsight bias. And there is one more uncomfortable fact that the bullshit patent screw the trolls narrative skips. This family of patents wasn't dreamed up by a random shell company. It was originated with Daniel Abelow, a solo inventor, and later moved through assignments before ending up at Lodsys. So, with that as a primer, let's go into patent trolls. All right, let's talk about my favorite topic, patent trolls. The actual term is non-practicing entity, or NPE. That means that they own the patents, but they don't manufacture products themselves. They make the money by licensing and enforcing the patents. But here's the uncomfortable reality. For most individual inventors and small companies, a patent without an enforcement mechanism is basically a very expensive wall decoration. So to understand how patent trolls really actually benefit the system, you have to get into how the sausage is made. Big companies, and I've been on the receiving end of this, get tons of inbound messages like, hey, you're using my tech, can we talk about a license? Most of those conversations go absolutely nowhere. The unwritten rule is, if you can't afford to sue us, we don't have time for this conversation. And that's not necessarily these companies being evil, that's just the math. Patent litigation is brutally expensive. Maybe that's something we can talk about how to fix and get lower. But an indie developer with one patent and a Gmail account cannot credibly threaten Apple or Google. So what are their options? Hope that a giant company is feeling charitable, or sell the license and the patent to somebody else whose entire business is enforcement. And of course, that someone is what we know as the troll. Patent trolls often buy patents from inventors, startups, bankrupt firms, even big companies exiting a line, and they take on the risks and the costs of the enforcement and sometimes share proceeds with the original inventor. So let's get this out of the way. Are there bad actors? Of course. Do they shotgun demand letters like jerks? Yes. Do they misrepresent the scope of their patents? All the time. Do they target the wrong people? No question. But there are also cases where a non practicing entity is the only realistic path for a valid patent holder to get any value when a much larger company uses the tech. So I like to think about it this way. If somebody invents a breakthrough technology in, say, refrigerant coolant technology, do they really need to become Refrigerator Startup Incorporated and compete with Samsung and LG just to enforce their patent? Of course not. We don't require drug inventors to own a pharmaceutical factory. We don't require in copyright a songwriter to open a record label before suing for copyright infringement. Property rights are transferable. And as we briefly mentioned earlier, we can debate about how patent trolls should be able to enforce these things. Fee shifting for abusive cases, litigation costs, venue rules, all of that. But saying a non-practicing enforcement is illegitimate by definition basically means that if you're not already rich enough to build and scale a product company, your invention doesn't matter. That's great for the big guys. It's terrible for solo inventors and small R&D heavy companies. And it is also terrible for the small guys when we get into IPR. IPR is a proceeding at the USPTO's Patent Trial and Appeals Board, the PTAB. It lets somebody challenge an issued patent based on prior art patents and publications, basically novelty and obviousness. Inter partes views are designed to be faster and cheaper than a full federal court trial. Often it finishes on the order of roughly 18 months, and it may cost hundreds of thousands of dollars instead of many millions. GitHub's argument is that developers and startups need broad access to the IPR system to knock out junk patents that never should have been issued. And that position is understandable from the point of an accused infringer. From the point of view of a small patent owner, it can look really different. Let me give you an example from my own practice. Years ago, I worked with a company in the non-lethal ammunition space, specialized rounds for training and crowd control, basically. They did about $10 million a year in revenue. Not a FANG giant, a very medium company. Their business model depended on IP licensing. They didn't do the manufacturing, they basically licensed their technology out, so their patents were their value. And of course, somebody copied them. We reached out to them, they refused. But instead of just fighting it out in district court, the infringer did what the big players now do routinely. They filed an IPR petition with the USPTO and then asked the federal court to stay the infringement case while the patent court decided the validity. So now my client is paying district court litigation counsel, paying IPR counsel and experts, and watching licensing deals stall because potential partners get nervous. Hey, we love your tech, but what if the patent dies at the patent court next year? IPR isn't free. A fully contested IPR can cost hundreds of thousands of dollars in legal and expert fees, plus USPTO fees. For a $10 million revenue company, that can mean freezing hiring or canceling projects. So that's the issue in all of this. Even if they win and the patent survives, they've burned huge resources, lost licensing momentum, and the district court case may still be waiting on the other side. And it's also worth noting that they attacked validity in IPR under a lower standard, a preponderance of the evidence standard. And then they get additional shots in district court for what survives, where the challenger faces a higher, clear and convincing standard. Meanwhile, the patent owner is paying lawyers in both forums, dealing with business partners demanding contingencies and discounts, and stuck in limbo about whether their core assets exist next year. So, when you hear easy access to IPR, understand what that means in practice. It can mean forcing a patent owner into a six-figure administrative fight that often freezes the parallel court case. That burden does not hit Apple or Google the same way. It can crush small patent-centric companies. The USPTO proposal GitHub and Theo are worried about is pretty specific. It would limit IPRs in certain situations, like where the claims have already survived a validity challenge, or where a parallel case is likely to finish first anyway. In plain English, it's trying to move towards something like the one and done. If validity has been fully litigated and a challenger lost, we don't need to endlessly relitigate the same patent over and over the same claims and prior art. So GitHub's post frames that as the problem. If a big company challenged and failed, a startup later suing might lose its own chance to attack the patent in inter partes review. From a patent owner's perspective, of course, that's the point. It creates stability after a full fight. It reduces the death by 1,000 IPRs. It makes licensing possible without permanent fear that the next petition blows everything up. So I've given you the patent owner side in this. There is plenty to debate in the details. I am not saying it's perfect. But a cartoon conspiracy to help the trolls, it is not. It is the patent office trying, maybe imperfectly, to balance challenging bad patents with keeping good patents usable as actual property rights. So that said, I obviously agree with a lot of Theo's video. There are abusive assertion campaigns that target people who can't find back. Some patents that issued are genuinely low quality. You don't have to tell me I once patented the position of a like button on a DVR. And developers shouldn't feel like they're stepping on a landmine every time they ship code. But I would like it if people broaden their thinking on three things. First, bullshit patents aren't always bullshit. If you go back to the 90s in context, Lodsys looks a lot less like we invented the upgrade button and more like an early architecture for network product telemetry and updates. You can hate enforcement and still accept that the original invention might not have been obvious when filed. Second, troll enforcement is not inherently illegitimate. Telling inventors you only enforce your rights if you can build a global product company is a great way to make sure only giant patents matter. Trolls can be the only realistic path for solo inventors and small firms to get paid. And third, inter partes review isn't just a one-sided pro-developer tool. It is also a powerful, expensive weapon that infringers can use to grind small patent owners down and delay everything. The current rulemaking is at least trying to address redundant attacks so patent rights are somewhat predictable again. So if you're a software developer watching this, I am not asking you to love patents. I'm really not asking you to love software patents. Actually, if I was forced to answer, I would probably get rid of software patents as a category. But what I am asking is this. Before you tweet, "This patent is obviously trash," just ask yourself, was it obvious at the priority date? Before you say all trolls are evil, consider the solo inventor who tried for years to get a big company to take his license seriously. And then before you insist that an IPR should be open and aggressive as possible, think about the small companies built on 2 or 3 patents staring down a $500,000 fight they never budgeted. The patent system isn't perfect. I know, shocker. It never has been, it never will be. It's 200-plus-year-old attempt to balance rewarding people who create new, useful ideas with not freezing the rest of the world for 20 years every time someone writes down an obvious thought. And obviously, that balance is messy. It's not going to be solved, though, by dunking on trolls or by assuming every old patent that annoys modern software developers must have been some kind of mistake. I really appreciate, though, that Theo used his platform to get people paying attention to this, and I appreciate Theo personally. He's been more than kind and gracious to me. We should, as a community, be talking about the patent board, IPRs, patent quality, and the rest. I just think the story is more complicated than patents bad, trolls bad, IPR good. So if you found this helpful, or even if you totally disagree but learned something, let me know in the comments. And if you're going to jump into policy debates like the current USPTO rulemaking, read at least one patent you're calling junk. Read GitHub's post and at least one commentary from the patent owner's side. I just want this conversation around patents to be less Twitter thread and more grounded in how the system actually works. Hopefully you got to see a little bit about how the sausage is made, and I really appreciate you watching. I'll see you next time. Legal drama inspires me to turn on this camera. If you have a video idea, though, leave it in the comments and follow for more legal software drama and deep dives.